So to seek relief and under principle of unjust enrichment um, for the so the principle of unjust enrichment states that no person should be allowed to profit at another expenses without making restitution for the reasonable value of the property, services, or other benefits that has been unfairly received and retained. So in the case of Fibrosa versus Fairbairn, it says that it is clear that any system of law is bound to remedies to prevent when retaining the benefit derived from another which is granted by consciousness that he should keep. Unjust enrichment will be defining status and obligation to restore property or make payment in the extended of enrichment. So yeah, so the principle of action against unjust enrichment says that defendant must be enriched of the receipt or benefit, and enrichment should be expenses of the plaintiff, unjust to follow the defendants to retain the benefit. Yeah, so generally, normally, so would do that the court will grant relief to the plaintiff that he has spent more money, he is the one who worked hard, and so and the B hasn't done anything, but he also gained a profit from it. So that's why it says that no person should be allowed to profit at another expenses without making restitution for the another value of the property. So that means you can't just stay idle and get someone else's credit and to enjoy it. So that is a simple meaning. So yeah, defaulting party must have acknowledged and accepted benefit from the whatever the aggrieved party provided. Yeah, so these are the actual things that you should be granted. God. Sorry, it happened again. Yeah, so the unjust enrichment is not granted. Places like a party who makes a payment or delivery under the mistake of law is supposed to mistake, and enrichment should be entitled to restitution and error arising from gross negligence. So to recover is especially renounced. Yeah. So let's go to the privity of contract. So the principle of privity of contract. So it means a doctrine of privity. So make sure that this is also like another heavily relying on part of contract right. So this means that only a party of the contract has a right to sue, to be sued upon it, and A, the third party, which is not a party of the contract, does not have getting rights under the contract. Furthermore, it can be imposed liability on a third party. Yeah, so such as X and Y entered into a contract, and X agreed upon to pay Z upon Y, performing specified tasks. Y performed as stipulated, but X did not pay to Z. Under period of contract, Z cannot enforce X's obligation to pay Z. So Z was not a party to the original contract. Only Y can enforce this contract by suing X. Yeah, so classic examples, and there are definitely cases such as D cannot sue S, as S was not a part of the original contract between D and C. Yeah, so Dunlop Tire Company versus Selfridge. So this is an actual British a common law case. Yeah, go ahead and please free to research upon that, and I believe there are case facts as well here. And prescription period of contracts. So prescription ordinance of number 22 of 1871. This is a Sri Lankan law which was done during the British colonization time. It says that lay down his laws regulating the prescription act, section 6 of the ordinance stipulated by the time of frame within the action or the breach of a contract should be initiated by the aggrieved party. If the aggrieved party fails to initiate the proposed within the stipulated time, the ordinance prohibited him or her initiating an action for that particular breach thereafter. Yeah, so there are sections as well, from section 5 to 10, what sort of a prescription period of contracts are there. So it says, but if aggrieved party does not do within 6 years of the date of breach occurring, they cannot, eyes of the law, they cannot go to the law, they can go to the courts. So there is a period of time if an actual contract has been breached and you have obtained a huge loss from the other party or parties, within 6 years of period of on that time that was breached, you can go to courts. But after 6 years later, you cannot go to courts because eyes of the law, it's known as a redundant. So it will be useless. So has to done within a 6 years period of time. And yeah, that's it for now. So there are a few questions, and please free to answer them and send it to me, and I will be here. So the next chapter will be sales of goods, chapter 3, and I will be continuing that within two videos as well. So until then, see you all.